thank you all for being here. We really appreciate your time, and we appreciate our sponsors' support. We have great sponsors for this event, all of our events really, but in particular, we really appreciate the sponsors pivoting with us so quickly to be a part of this program. So I've stalled a little bit here to let everybody get into the room. Our numbers are growing, and they'll continue to grow, no doubt. Had over now 700 people register, and we've been getting close to 350 of you present while we're doing the panel so far today. So Renee, let me kick it over to you, and you can introduce our speakers.
Absolutely. Thanks, Gene. And welcome, everybody. We're happy to have you here. Pardon me. Excuse me. On our panel today, we have the Honorable Paul Michel. He's a former Chief Judge of the U.S. Court of Appeals for the Federal Circuit, where he served for over 22 years and authored hundreds of patent opinions. A towering figure in the IP law, Judge Michel continues to shape patent policy through scholarship, advocacy, and public appearance. Next, we have Joe Mattal. He is principal at Clear IP and a former acting director and acting solicitor of the USPTO. He played a key role in drafting the American Invents Act and defending the PTAB in landmark Federal Circuit and Supreme Court cases. Joe brings unparalleled insight into PTAB jurisprudence and patent policy. Next, we have Phil Warwick. He's an attorney at Irell & Manella, whose practice focuses on patent litigation appeals and IP policy. A former associate solicitor at the USPTO and IP counsel to Senator Chris Coons, Philip brings experience from all three branches of government to complex patent disputes and policy matters. And last but not least, we have Brad Watts. He's Vice President of Innovation Policy at the U.S. Chamber of Commerce's Global Innovation Policy Center. He previously served as Chief Counsel to the Senate Judiciary IP Committee, helping shape federal IP legislation. Brad brings a frontline policy and legislative perspective on the innovation economy. Back to you, Gene.
Great. Thanks a lot, Renee. And again, thank you all for joining us here today. You all will get, all of you who needed at least CLE for this panel. We have information on IP Watchdog on the PTAB pages about where it is that we have applied for CLE and where it is that have reciprocity with where we have applied. And I think we'll have almost all of you covered across the country. So thank you for coming for that and for also other reasons. And let me just also point out the CLE materials are on the panel URL on the PTAB program pages. And last but not least, if you have questions for the panel, please use the Q&A feature here in Zoom. If you want to chat amongst yourselves or you need some technical help from Renee's team, you can go to the chat and talk to your heart's content among the chat. It's going to get extremely busy, though, I can tell you for sure. So if you want me to see something to present to the panel, please do put it in the Q&A box. And then last, I lied, there's one more thing here procedurally. Since this is a CLE panel, we're going to be having a few polls. So one of the ways that we can, if ever asked, verify that you were here and present and paying attention is if you will do the poll questions, even if the answer to the poll question is simply, stop already, I'm just here for the free CLE, which we have as a choice on several of the questions. So just to interact with us a little bit, and we'll make a record of that, and we appreciate your time as always. So gentlemen, let me start with an open-ended question here. Well, actually, before I even start with the open-ended question, let me just give you an open microphone opportunity. The topic of the day is inside the Beltway, what's going on, Capitol Hill and PTAB politics. So Judge Michel, will let you lead off here. What is your big picture theme that you think folks should have their eye on as we start to move into the legislative cycle of 2026?
Stability and predictability are key. Chaos is the enemy of investment and innovation. We have too much chaos, and we need to work out a system where we can get some steady equilibrium that will last.
Okay, excellent. Great. Thanks. Joe, let's go to you next. I'm not going to blame you for the PTAB, but you were there at the time when all of this was going on. So maybe you have some thoughts to lead us off about that.
Yeah, Gene, I apologize that we used to have a system where you could get an accurate and technically sound evaluation of the validity of a patent. It really, reduced those NPE revenues, which apparently the current leadership has decided is the is the main purpose of the system. The
So
story
already pulling the pin and rolling the grenade already.
yeah, the story of the last year is the agency is basically being led by people who have decided to gut the board, who have decided they're just going to make up their own version of 101 case law, seem to be doing as much as they can to drive talented people out of the patent organization as well, and making everyone's life miserable. Where this bottoms out, I don't know. So far, the Federal Circuit has taken a hands-off approach to this, has basically taken the view that the statute is unenforceable. Remains to be seen whether someone tries to take that up to the Supreme Court and apply their somewhat different version of how admin law works. With regard to, one interesting thing to watch this year will be what happens at the White House with things like the NPRM rules package. While you have the PTO doing these things, and basically, it's now basically impossible to reliably get access to validity review in post-issuance proceedings at the agency. They now have an NPRM in place that would that's up for comments that would lock in these changes. I'm really curious to see whether the rest of the administration is really behind this, because while this is going on at the agency at a sub-cabinet level where, again, like most people who aren't involved in patents don't pay any attention to this, you have the rest of the administration talking about how we're going to strengthen manufacturing and bring back our manufacturing base. And then another part that talks about like all these efforts to lower drug prices, all of which seems really contrary to the idea of allowing non-practicing entities to sue manufacturers in East Texas without any meaningful validity review of the patent. A number of these cases that have gotten discretionary denials are also drug cases. It's a small part of it, but just a few cases have a big impact. At some point, the administration as a whole is going to have to decide, like, are we going to let Lutnick and his minions do this? Is this really going to happen? Or, do we actually care about, protecting the advanced manufacturers who are still trying to make chips in this country and RAM memory and networking equipment and things like that? Or is the US's new IP policy like, no, we can just get that all from China, and anyone who dares to manufacture stuff in this country is a sucker, and we're not going to allow them to defend themselves even if they have a good case that the patent being asserted against them is invalid.
Well, geez, I better start reading more, because I didn't know any of that. I mean, I didn't realize Judge Gilstrap stopped doing validity. I didn't realize that the Federal Circuit stopped doing validity. I'll have to read up on that, because I thought it was still able to be challenged in federal court. I must have missed that update. I'll look for that, and while we get some more comments, I'll look for that change to the federal rules of
Gene,
evidence.
just out of curiosity, you're a lawyer in private practice. If you have a client who has been sued on a patent and they think they have a good patents and printed publications case of invalidity, that this aspect of chip design was already known, do you tell that client, you know what, don't bother with the board, just go to a jury trial in East Texas, that'll be just as good? They'll really
again,
get to the bottom
I
of
didn't see the Supreme Court I didn't see the Supreme Court overruling TC Heartland. I must have missed that as well. I mean, because most of these cases aren't in Texas. I mean, I don't know. I'll look and see while this unfolds. But Phil, let's get your preliminary thoughts here.
Sure. I mean, like I'm not really here to take a side on the policy bias. I'm pretty sure re-exams still exist, and I know we have clients that are fighting validity in district court. So I'll just put that out there. But for our panel, we're talking about Capitol Hill and DC. In my mind, I think we're still kind of stuck where we've been for a while legislatively, which I think is unfortunate, because I think everyone wants certainty. That came out in the morning panels. I think wherever you are in the innovation ecosystem, reliable rights, some sort of predictability about which patents will stand or fall, how enforceable they will be, how likely judgments are to stand up on appeal. That benefits everyone. And I think legislation is the best option for that. And there's been legislation pending. I think there's good legislation out there. The odds of everyone coming together and passing that, I think, are pretty steep. So as we talk today, I think what we might be talking about is a lot of people have strong feelings about what's going on in this administration. And I think, well, I know there's a lot of lobbying going on behind the scenes. And maybe these are people going to the White House, these are people going to Commerce, people going to senators or members of the House and saying, can you make some calls? Can you write a letter? Can you send an email? Any way they can to kind of like tilt the system a bit in their favor. But I think ultimately what we really need is legislation for more clarity. And unfortunately, I don't see that happening immediately. And with certain people leaving, especially Senator Tillis, who's been such a champion for IP rights and for, policy making in this area, leaving the Senate, I'm not sure when we are going to see that, unfortunately.
Okay, great. And Brad, the final word on the initial take goes to you.
Well, first off, thank you for inviting me today. I'm here on my own behalf, not representing the chamber, but obviously I can, if it comes up, state any position that the chamber may have. A little mad at my friend Joe Mattal. Usually I'm the one that gets to throw grenades, and now I have no grenade to throw. It- all jokes aside, um, I tend to agree with what Judge Michelle said at the beginning, right? I think this all boils down to, and Phil kind of alluded to this as well. Everyone has their own, I think, perceptions and views of what the right standard should be, what the right fix, what the right operating procedure should be. I do, where I sit, though, increasingly see people becoming concerned about the lack of predictability and certainty and stability, right? Predictability you don't like is still predictability, right? Same thing if it's predictability that you do like. Obviously, some of the member companies I work with appreciate some of the changes that have been made. Others have concerns. But I think there is a growing realization, kind of to Phil and Judge Michelle's point, that these swings back and forth every 4 to 6 years are not healthy. Now, the reality is, as Phil noted, next year you're going to have a lot of folks who have traditionally been leaders in IP policy, not in Congress, through a combination of factors. Who picks up those mantles and really tries to legislate in this area, which, as Joe knows better than anyone, is very difficult? I don't know. At some point, I do question whether it's this administration or a future administration, is there going to have to be some type of detonate where people realize these very wild swings in interpretations just over the long term are not healthy for the system.
Mm-hmm. Okay, great. And Judge Michelle, I'll go back to you and give you an opportunity to come on anything that's been said so far, if you would like.
Thank you, Gene. In terms of the paralysis on Capitol Hill, it goes back a full decade. I mean, even though the current version of PREVAIL, for example, was only put in about 3 years ago, the prior versions, which weren't very different, were written in 2013 and introduced within about a year of that, if I recall correctly. So it's been around a long time. Same with PARA. The bill on injunctions, Restore, hasn't gotten out of the starting block, so it's also a victim of paralysis. The forces on both sides, just broadly dividing the whole user community into two fundamental camps. There are a lot of people who are in different parts of the spectrum to one degree or another, but basically we have a complete split between people who want stronger patents, to put it simply, and people who want weaker patents. And that goes to eligibility, to validity, to enforceability, to remedies. It's across the board. In other contexts where Congress has been effective, to my understanding, it's usually been because there was a fair amount of consensus developed. But you can't develop consensus very well in the current circumstance for two fundamental reasons. You have some very good leadership in the House and the Senate by knowledgeable legislators who care. But what you don't have is any kind of balance of power. I had a law clerk who worked for a big tech company. And every year in December, I would have lunch with that law clerk. It just became a regular nostalgia fest. And every year, this clerk would say, the anti-patent forces are not even going to negotiate because they're so confident that they can defeat any bills that they don't like, that they see no reason to negotiate, no reason to compromise, even to a small degree. So that's the first problem. The second problem is that the division is so bitter that there's no one individual that both sides would trust. And in prior cases where somebody worked out a creative compromise, it usually involved a person adequately trusted by both sides or all factions, if you want to divide it further. I can't identify such a person now. So you have the terrible split, huge amount of money involved, huge lobbying power, view of High-Tech Inventors Alliance and their many allies, many strong allies, that they don't need to compromise, they don't need to negotiate, they're not going to. The other side is not strong enough to equal, much less overcome that force. So of course you get stasis. Now, if the dynamics changed, I could see a slightly modified version of PREVAIL passing. But what would be required would be for the anti-patent camp to be so worried about further advance of what I'll call the Squire's agenda that they end up deciding they'd rather have a slightly watered down version of PREVAIL. Forget about PARA, that's too complicated, but at least of PREVAIL, than to have to live maybe for a long time with what I'm calling the Squire's agenda. So it's a perfect storm, to use a cliche, and it's very hard to see how that set of dynamics could change. And I'm very glad, and this is my final point, that there was great reference to lobbying going on at the National Economic Council and in other parts of the White House, as well as in the Commerce Department and all around, because the PTO is not in charge of the federal government. They may wish they were, they may sometimes think they kind of are, but they really aren't. And you have an awful lot of players, and they have inconsistent agendas and goals. So they're not going to be able to agree any more than the stakeholder community is able to agree. So it's a very unfortunate circumstance. And the other thing is that whatever the Squire's Patent Office can do, the Federal Circuit may overrule a lot of it. So then you just get more unpredictability, instability, chaos, expenditure, delay, unnecessary litigation. So it's not a healthy regime from whatever angle you want to look at it. And we need to try to find out a way to overcome that paralysis, because meanwhile, Europe and Asian rivals, particularly China, are going to sprint ahead and overtake us in a lot of areas, which is the last thing that the country needs, and I would even say the last thing the world needs. So the stakes are global and enormous, and nobody's doing much about them. I'll quit there.
Yeah. Okay. So, Brad, I want to come back to you next, and with a specific ask, and then also a comment. So during our pre-call, I'm 99% sure it was you, and if it wasn't you, I apologize. But I think it was you who said that, if we do not get legislation over the next X period of months, and I think Judge Michelle, you even suggested maybe it's shorter, we're not likely to get it for maybe 5 or 6 years. And I was wondering if you could explain that to the audience, number one. And then number two, I think wrapped up in that will be conversation about Senator Tillis's involvement. And, for those of us who watch the evening news, it's hard not to notice that Senator Tillis maybe isn't President Trump's favorite Republican at the moment. And what might that have what implication might that have if you could address that?
Yeah, I think I did say the first part. And I think
Yeah, no,
Phil,
I'm asked the second part
yeah,
is a question I asked. You didn't say
yeah,
that.
yeah, yeah, yeah. And Phil alluded to this, right? I mean, Senator Tillis is retiring, Senator
Mhm,
Durbin is retiring, Senator Blackburn, I believe, is running for governor of
mhm,
Tennessee. Obviously, you know, in the House, there's a number of factors that may implicate membership next year, not just the election, but redistricting. You have people changing committee assignments. All of that to say, I think you're going to have potentially five, six, or more legislators who, were leaders on this, and I mean leaders across the spectrum, whether you agree with them or not, who may not be in Congress, right? Joe
mhm.
knows this well from his service on Senate Judiciary. This is not an area where people tend to just pick up the ball one day and start running with it, right? It takes time, it takes study, it takes good staff training. So I think just the natural reality of the change we are facing politically means it's going to be several years before some of this momentum builds back up, especially when you juxtapose it with everything else going on in the world and the issues that Congress has to deal with. Um, I think whatever current political challenges my former boss is dealing with in terms of how the administration views him, I don't think that's probably going to have much impact on his IP work, simply because I think the issues there are not particularly partisan. People just have very divergent views on what the right answers are to some of these very tricky questions. So, all of that to say, I don't see really any legislation happening this year independent of PTO's pending fee renewal. I
Mhm.
do hear rumblings that there's enough um, animation on both sides of the issue right now that probably is brewing into much of a bigger fight than it probably should be. But independent standalone legislation, I don't see a pathway forward. And then I really view the next probably 2 to 4 years as wilderness years, where advocates on any side of the equation are going to have to develop new allies and re-educate a lot of staff and really find members who are willing to do the legwork,
Mhm.
which is not
Okay.
easy, even in the best of
No,
circumstances.
no, no. So I'm going to ask Phil a question, and I'm going to ask Joe a question thereafter, and then maybe we could get into like a roundtable of all the issues that have kind of come out on the floor. And Phil, one of the question for you, I guess, since you're frontline representative for a number of patent owners, right? I mean, you do work for them and dispute resolution, that sort of thing. What are they telling you in terms of how concerned they are, whether they like where it's going, whether they wish it would go further or different? What can you share? Well, obviously, without sharing any confidences, but general sentiment in your client ranks.
Thanks, Jane. I mean, I should point out that we have clients on both sides.
Phil, we're losing you on the mic.
We're losing your audio here a little bit,
Oh, can you hear me?
barely. Let me go to Joe, and while Phil works on his audio. Joe, the question I was going to ask you was going to be one about, and I think I know what your answer is. So I'm kind of in some ways teeing you up to lay your marker down, and then we could have a conversation about this. Is this the PTAB that you think Congress, and at the time that this was going through, you were Senator Kyle's right-hand man on this, I believe, right? Is this the PTAB that the Congress thought we were going to be getting? Was it ever the PTAB Congress thought we were getting? Or, and I think now probably your answer, this PTAB right at the moment, would not be. But general thoughts on expectations.
I see a lot of people like opining on congressional intent, behind the America Invents Act and other bills.
Mhm.
For one thing, a lot of people are involved in these bills, so it's not anyone's intent that matters. And fundamentally, Congress expresses its intent through the text of the statutes and enacts into laws. So you can divine intent just as well as I can by looking up the statutes. This whole notion that like compliance with the statute is actually discretionary is something that kind of cropped up in the FedSur decisions, I think I first saw this in Apple v. Vidal and the decision on Fintiv, where they said, well, it's only the institution decision that is, the statute says is unreviewable, but we're going to interpret that to mean that anything that touches the institution decision is also unreviewable. And so whatever policy the director adopts, it's infectious non-reviewability. It's also non-reviewable. So, the statute may say that you have 1 year after you're sued to file, but if the agency wants to shorten that, that's fine because all policies related to institution are non-reviewable. I'm pretty sure that's not what the members in Congress who enacted this and voted on it had in mind. Just the deadline for filing in relation to litigation. There was back and forth debate on this, even between the two houses. The bill that originally passed the Senate would have required you to file a PTAB petition within 6 months. And it was institutional defendants who envisioned using this who said, wait a minute, that's not long enough. There's going to be a higher bar for starting these. You're going to have your complete invalidity case. We also need to know what's happening in the litigation. It needs to progress a bit so we know which claims are being inserted. Let's extend it to 1 year. And the two houses went back and forth and eventually agreed on the House position that Lamar Smith insisted on at the time. The notion that you can have the entire House and Senate negotiate this, pick 1 year, and then the agency says we think they got it wrong. We think a shorter time period, is actually appropriate. I remember in the NPRM that was proposed several years ago, they just proposed shortening the 315B deadline to 6 months. And under the current Federal Circuit interpretation of, infectious non-reviewability, as long as something touches the institution decision, then it becomes unreviewable. This is all okay. If someone manages to get one of these cases into the Supreme Court, which is never a sure thing, it doesn't matter how good your case is, you can never be guaranteed of getting into the Supreme Court. I think the Supreme Court will look at this very differently. They tend to have an opposite presumption, a presumption of reviewability, that review bars are interpreted narrowly. And I just can't imagine the Supreme Court saying that Congress can enact this kind of detailed statutory scheme with thresholds and deadlines and statutory estoppel, but that's all just optional for the agency. That is not a vision of admin law that is recognizable in the Supreme Court's jurisprudence. And
so I wonder about that though, and the reason is so at the patent office. So let me take a step back. I'm not sure I would be doing these things the same way that the patent office is doing. Although I think I personally like the philosophy and what they're doing, but on the patent side of the building, the patent granting side of the building, Congress gives 6 months. And the office has always said, no, we're only going to give you 3 months. And then if you want any more of the time that Congress said you can have, then you just got to pay more. That always rubs me the wrong way, much I think the way that, you're suggesting here. But this is to some extent the way the patent office has operated and been allowed to operate across the board forever, as far as I know. And I'm not a fan of anything being non-appealable because I think you have to have an error correction mechanism. Not everybody gets everything right. And so a lot of this bothers me. Before we go down too far down that particular avenue, I want to see if Phil's got his microphone working. Phil, can it?
Hoping so. Can you hear me?
Yes.
Okay, great.
So maybe we could go back to where we were, and then we can go into the round robin free for all. But what are your clients telling you is sort of the short question that I asked you?
Sure. And just point, we do have clients on both sides. But I think it goes back to the predictability. The clients are making business decisions. And so they want to have a good sense of at least what the playing field's going to look like. So it is very frustrating when there's so much change. So I think to that end, there's at least hope for something like a rulemaking process, and some like the proposed rules and some don't. But at least that seems like something a little bit more permanent, and legislation would be even more so. But that's really what it boils down to. And I also talk to a lot of funders, and the funders will say, look, as long as we kind of understand the system and the rules of the road, we can build that into our models to know what makes sense and what doesn't. Uh, so I guess that's the short answer to your question, Gene.
Okay, great. So let me throw this out there, and I think this will get into a question about, where we were, where we are, and maybe where we're heading with it. Understanding this panel is about inside the Beltway and what's realistic and what's not realistic and all that sort of stuff. One of the things that has frustrated me about the PTAB from its inception, and maybe not its inception, since we saw how it started to work. And this, I think, was it's a design flaw, in my opinion, is that I thought what we were setting out to try and do is to go after bad patents used by bad people, i.e., patent trolls, from holding up, mom and pop manufacturers, as Joe was saying, these people who are really doing something. And it seems to me that the only group of people who have been unaffected completely by the PTAB are those people who are willing to take extortionary level settlements, $20, $25, $50,000 settlements, because the filing fees for IPR are more than that. And so it's frustrating. I brought this up in an earlier panel a little bit, alluded to the fact that, there is director instituted reexamination, doesn't get used a lot. I don't know that there could be director instituted. I don't think the rules or statutes would allow for that on the PTAB side. But some of this would become, I think, from the patent owner's perspective, a lot easier to swallow even if you don't like it, if those people who were really the bad actors, and we could define them. I think even all of us with our different views on this panel could come out and largely agree on who they are. If there was a resolution for them, that seems to be low-hanging fruit, and I don't hear anybody talking about that.
Gene,
go ahead,
people, those people tend to get hit by two things. The people who just settle for, kind of like 5 figures cost of litigation, they tend to get hit by two things: either ex parte re-exams, which are, still fairly cheap. And often they just don't even bother to reply to those. The other thing they tend to get hit by is unified patents. If you settle quickly, most institutional defendants, most manufacturers will just always settle for something that's, if it's way below the cost of litigation. And you'll see these people who bring, scores of these suits, sometimes over 100. And the only thing that tends to shut them down eventually is when Unified goes after them, because Unified doesn't have any interest in settling. This is what they're in the business of doing.
And that's on their website. They say they never settle. And, and I get that. And there's been people like that. Like, I think it was, maybe I get this wrong, I think it was Gateway always decided it doesn't matter how much you're asking, we're just not going to settle. We're going to fight anything. And that, for companies like that, then they tend to get sued a lot less.
Yeah,
because that's not the model.
It's just hard for a defendant that's in business, an operating company, to do that. Just,
right.
Some of these companies, like the biggest ones these days, you basically get sued every week. About once a week on average, you get a new lawsuit. Like, how many times are you going to spend a couple $1 million on litigation? If someone wants to settle for a reasonable sum, just the economics of it, you're forced to,
No, and I get that. And I guess, and I understand it. I don't like it. I get it. And because I do think that, once you paint a bullseye on your back, then you get shot at a lot more often. And I also think that the policymakers, and I understand they're doing all kinds of other things, right? I mean, there's wars all over the world. There's inflation is still higher than we want it. There's protests all over the country. There's all kinds of things that are, not to suggest that patents is the one thing that they should be talking about every day. But I wish that there was some attempt to try and make the system better. It feels like, we do this, we set it down this course, and what should have happened was a course correct at some point in time to say, okay, well, wait a minute, we were trying to get rid of these really bad actors. They're still there. Something needs to be done there, and switch some levers here and there. That's the engineer in me wants some levers switched, and I don't think that's realistic? I mean, Judge, let me go to you. I mean, do you have any belief or hope that there could be that kind of holistic view of what the system has become to see where it could be improved and where it should be changed?
Well, there could be if people would come together in good faith with a common goal of a system that would work pretty well for everybody in almost every circumstance. That's a possible goal to pursue. But there's no will to do that I can see. Everybody is elected to fight for their maximum advantage and heck with everybody else. Now, the point was being made about whether adjustments needed to be made to the post-issuance review system set up by the AIA. We already seem to agree that the prospects of passing patent reform bills like PREVAIL are not so great and maybe won't be very good for years. The prospects of amending the AIA, to me, don't look any better. For the same reason. There's too much conflict and there's no willingness to come together or to compromise. So we need some kind of solution other than duking it out in Congress in all-out combat year after year, decade after decade. And I think the only way anything will ever pass, whether it's to fix design defects in IPRs or PGRs for that matter, or to fix the PTAB regime, or to fix eligibility or injunction or anything else, the private sector would have to come up with a compromise that would have broad support. If the private sector could do that, Congress could pass that. Absent that, I think the chance of any congressional solution to our dilemma is nil.
Mm-hmm.
Hey,
James,
Phil,
go ahead.
Yeah, go ahead, Phil.
Yeah, I just want so one thing, you hear a lot about like these the nuisance suits, and I've been on the wrong side of those. I spent several years doing almost exclusively defense work, and they're very annoying, and the clients certainly are very annoyed by them. I am worried a little bit about the tail wagging the dog. I mean, you have nuisance litigation in every aspect of litigation: tort litigation, product liability, employment. Someone's going to sue, say, give me 20 grand to go away. And I'm not saying by any means that's a good thing, but it shouldn't drive the overall policy. And the other thing I observed when I was on the defense side mostly is there was a lot of people banding together. Even before we had unified, you would have usually those types of actors go after a lot of defendants. And it may not make sense to file a re-exam or an IPR if you're just one of them, but if you're 10 of them, you pool your resources, it makes sense. But on the point the judge was making, I actually do wonder if maybe not immediately, but if we could be setting up the potential for some sort of compromise. When I was on the Hill, I sensed one of the problems was that you need to have give and take on both sides. And for people who are being accused of patent infringement, over the past 20 years, a lot of things had gotten better. Obviousness law got better. Injunctions mostly went away. 101 law got better for you. The PTAB was developed. But now, if this holds, say this rule package holds, and there is meaningfully fewer IPR petitions being granted, fewer IPRs being instituted, maybe there's a motivation to make some sort of trade where we say, okay, we're gonna set some different rules for post-grant review, and something else is on the table, whether it's injunctions, rethinking those, 101 law, or something else. And I think that's a little ways off, but maybe we're actually setting up a situation where compromise could happen.
Some of us are trying.
Yeah. Well, and that's, I think, one of the things too is when Judge says that the industry has to come together with a solution. That's, I think, usually the conventional thinking. But I do think that if you had the petitioner side come together, then it makes it far more like, and now I'm thinking out loud here, it's unfair to say that the pro-patent forces have ever been together, because They defy corralling, they defy even helping themselves at times, it seems. But I do think that maybe there could be potential. We'll wait and see. Joe, did you want to say something as well?
Just well, I guess this is consistent with what others said anyway. I hate to be a wet blanket, but I think it's pretty clear nothing is happening this year.
Mhm.
There are rumors of like Tillis wanting to get a legacy, a win on the way out the door. That's not how things work. Like as soon as a member, as soon as you announce you're retiring, all power seeps away from you, and everyone starts to think about the fact that in a year
Right.
you'll be gone and they won't have to deal with you. That
Mhm.
said, like, 2 years is an eternity, and once Tillis is gone and a number of other members are gone, different members come in. Typically, like you're, 90+% of members of Congress or the Senate don't have any views on IP policy.
Right.
They don't come into office with a strong view on how 101 should be drafted. And typically, what's happened in the past is Congress kind of mediated among different interests, and the stakeholders recognize that. And what you tended to get is the stakeholders themselves coming together through traditional IP organizations like ABA or IPO, AIPLA, and a deal was cut there and then kind of brought to the Hill of, hey, we all agree on this as something that would advance the system. You could probably write a poli-sci history book on why that system fell apart and atrophied. I'm, not really sure why, but I think we probably would be better off if we return to that kind of system where people are forced to kind of work out deals off campus and then
Mhm.
come to Capitol Hill once there's consensus. These issues are just very complicated, and the idea that like I don't know if any of you watched the recent Senate hearing on PARA, the eligibility bill, but it just the idea that like these members are going to work out all of these issues just seems highly implausible to me. That hearing seemed to go very badly for the bill, by the way. It struck me that when
Yeah.
Phil and Brad were still on the Hill, you'd hear a lot of movement and like negotiations on 101, and that seemed like the moment when something could have happened. Since then, we've just kind of been dealing with pretty much exactly the same bill for the last several Congresses that would basically make any business method eligible as long as you had to, couldn't be practically performed without using some kind of technology. And it just doesn't, all of the institutional defendants are never going to agree to that. I really don't understand why we keep having the same debate over and over again. I think we just need a fresh start, just to draw an analogy in the post-war history of the country of Turkey, about every 10 years the military would overthrow the government, but they wouldn't keep power. They, allowed democracy to
Right.
restart, but they imposed a rule that everyone involved in the old system is now banned from politics. I'm not advocating a military coup, but I think we could benefit from a system where we just start from scratch and just forget about all this stuff and go back to the drawing board and have like different sides of the V actually talk to each other about what would make the system better. God forbid.
Yeah, and I think in our space, and we're probably not the only space where this is the case, but I do think it's a little bit harder than a lot of people give credit for is in the patent space where you have the same law applied to acquiring the rights to then it's same law, at least the patentability requirements apply to challenging it at the office and then also apply in federal district court. But all of them have different burdens and different, standards of review, and you push in one place and it pops up in another place. You push down there and it pops up somewhere else, and that's one of the things that's really tough, I think, to understand. They're not to understand. It's easy to understand. It's tough to deal with. It's tough to get something that works over here for this little mountain that popped up and popping up somewhere else. The other thing I will say, going back to what Phil was saying, like I do think we have these bad actors are everywhere. They're taking advantage of judicial inefficiency. So I think one of the things that could be done is simply encouraging, because I do think district court judges have the power to do stuff. They're not set up to do this stuff, because a lot of these extortion settlements happen before there's even a settlement conference, and so the judges don't see it. I think if they were more proactive, they would see it and be less of a problem. But it almost seems like an insurmountable issue to try and. But where I get frustrated by the true troll issue is if we can't deal with that, if we can't, like where 98% of people in our community would say, okay, that's something we need to solve for. If we can't solve for that, then how the hell are we going to solve for all these other things where there really is honest to goodness, legitimate difference of opinion based on facts that that you've had happen to you, that had happened to your clients? And I don't know where we go from here. Brad, you made you sit and listen to the others, so I'll just throw it open-ended to you. React to whatever you want that we've said so far, and the rest of us will follow you.
Well, that's always dangerous.
Yeah. Well, let me rephrase.
Look, I think a couple of things, and I'll start kind of in reverse order. You hit on this. I've said this before, again, purely in my personal capacity. I know Phil has heard me say this, and Joe, I think Judge Michelle. Right. Everyone says they want a unitary patent system, right? But not everyone experiences the patent system in the same way, depending on what technology or art area you're in, right? Take the tax code, right? If you're trying to design a tax law, you can always do a carve out for somebody based on whatever, right? We tend to not do that in the IP space. So it makes consensus building near impossible because, you're exactly right. If you tinker with one thing because there's a real problem in one industry, it also impacts every other industry. I'm also going to throw a wet blanket. I'm going to join Joe's club and say, I don't see any private stakeholder negotiating occurring in the near term. And I think part of that is because people have started digging in and realizing, we can wait out whatever temporary thing that is occurring that we may or may not like. And, essentially like any gambler, right? Ride out on the stakes that, maybe in 2 years or 4 years when there's a change in power, we can now get all the things we want. It's a bit of a dilemma, right? Ironically, I think as PTO, and this is not a comment on the current administration, it goes back years, right? I think as PTO has started exercising that discretion more in varying ways, it has actually incentivized people to dig in more and to just hold out until they think they can get a better deal later. Why gamble and do all the hard work on legislation when in your mind, if you think, I can ride this out for 3 to 4 years and get everything I want with a stroke of a pen?
Yeah. Oh, this is a more depressing conversation than I thought it was going to be. I knew it wasn't going to be something I wanted to be a part of at the end. But I would like to be part of solutions, and it just strikes me as that this is one of those areas where, for the foreseeable future, it doesn't seem like there's any momentum for a solution one way or another. And I shouldn't be lament that too much, right? As a lawyer, this is the intersection where lawyers make money. When there's a lot of disagreement and people feel strongly about their positions, it just sucks for the whole system, I think. And
I agree with that wholeheartedly, Gene. That's what we hear from a lot of our members is that, again, put aside the substance of what you may or may not like about this administration or the past administration or the first Trump administration, that just from the health of the system, overall business development, Judge Michelle and I talk about this all the time, right? If you're a GC sitting in an office, right, having to game plan things out, and Phil, I'm sure, sees this all the time over 10 or 15 years. That's all of us can't even align on what we think may happen over the next 4 to 5 years. I can't imagine someone in a business unit feeling more confident than we do.
Yeah. We just got a question from somebody in the audience here about, along the lines of carve-outs, I've heard about patent small claims court idea floated. And the problem with that is that may be the greatest idea in the world. It just can't happen. It can't, constitutionally, it's prohibited because there would be more than $20 at stake. And they tried to do this recently with the copyright claims small court. And all you have to do and I know this for sure, is somebody issues a copyright complaint against you, you could just say, I opt out. and now they got to go into federal court. So it really does little more than agreeing to mediate or agreeing to arbitrate would. And I think it would be the greatest idea in the world if we could do it. We just constitutionally can't. Judge, I interrupted you, though. Oh, go
when
ahead.
Phil and I were on the Hill, I think, Phil, correct me if I'm wrong, I think our bosses both sent a letter to, I'm forgetting which quasi-government agency we sent it to ask them to do a study on a small claims court, and putting aside even the constitutional implications. And again, Phil, tell me if I'm misremembering. I think they essentially came back and said it's just not feasible from an economic standpoint. Like the number of people who would use it relative to the amount of damages you could potentially get, it would be of de minimis value. There's just no way to really make it work, independent of any bigger constitutional problems.
Yeah.
Gene, I think the only way that the stasis could be overcome would be if there developed a widespread fear of being technologically and even militarily eclipsed soon by China.
Yeah.
That could be so powerful to make all of the stakeholders be more willing than they've been to date to abandon their own narrow self-interest, bottom line money position, and realize that for the good of the whole country and having a system that would endure, they're going to need to compromise. I think it would take something that powerful to overcome the dug-in self-interest of all these disparate actors. And I'm not hoping that's going to happen, but it's hard to see any lesser force that could break open this logjam.
Well, I thought that was going to be the solution for a long time. I'm surprised it hasn't happened already. I mean, that was the way that we dealt with the malaise in the late 70s into the 80s and founded the Federal Circuit, was the fear, among other things, but largely a fear that we were going to lose technical superiority to Japan. And I thought we were maybe going to have one of those moments when China came out with those chips that were inferior chips that could do superior things. And I don't know whatever really became of that. I know there's a lot of people that were skeptical about that particular AI, but if something like that were to happen, then maybe it does crystallize these issues in a way that just hasn't so far. I don't know. I'd like to try and get a real quick question. I don't know whether any of you have any answers to this, although you might, maybe you particularly, Judge. Can somebody file a claim against the PTO under the Administrative Procedures Act to challenge what's going on? Or, I mean, what kind of standing would they need to do that? Any of you happen to know?
What are you talking about challenging?
I suppose that the question is about challenging, some of these Squire's initiatives where there are no rules, and I suppose that's what the question deals with. Is there an APA challenge that could be had there, or no?
Well, there's one pending. They just had an oral argument at the Federal Circuit earlier this month on a challenge to the Fintiv policy. The argument was that, look, if you're going to impose a policy like this, you have to go through APA rulemaking. You have to go through notice and comment, which, Fintiv never did. I didn't listen to the I filed a brief in the case, but I didn't listen to the oral argument. The consensus seemed to be that the Federal Circuit was looking for some way to get rid of the case, to hope it would be preempted by the NPRM or deem it somehow non-reviewable.
I'm getting so sick of judges doing that. It's like this has been the bane of my existence.
You and me, Gene.
Ever since law school, it's like, okay, you all know what we want answered. You all know what we need answered. It shouldn't take 2 decades to get a Commerce Clause decision from the Supreme Court. And it's like they inch and inch and inch and inch. And it's like, I don't know what the answer is anymore. I mean, I don't want reactive judges, but I don't want judges dodging what the issue is. And then at the same time I'm saying this, what's going through my mind is, when the one case where the Federal Circuit did hear en banc, it's like there was over $20 million, which, like, Google probably has, Google's not a person, but let's assume they're a person for a minute. They would have that pocket change in their front pocket to pay it out, and it's like, that can't be a system-wide question that deserve to be answered by all of the judges over and above so many of the other things that just we get dodged.
Yeah,
I'll get off my soapbox.
It is weird that nothing goes on bonk anymore. Before Ecofactor, I think the last kind of core patents case was Aqua Products over
Yeah.
amendments
And
and
before that, I think
IPOs.
it might have even been Apple, Samsung, and Judge, I mean, I know that's not this lane, but I mean, maybe it is this lane because people are talking about, do we really need a federal circuit anymore and that sort of thing. But what goes into the decisions to not want to have en banc hearings anymore?
It's a cultural issue. In the 80s and 90s, when I happened to serve on the court, there was a very strong centralized team spirit, very strong leadership, high desire to agree, to speak with one voice, to be moderate, to be practical, to try to make the system function for everybody as well as possible, not to duck questions. When there were conflicting precedents, we went in bank all the time, quickly. And in the 15 years, going on 16 that I've been retired, that has totally changed. The leadership style is totally different. The team spirit is almost totally gone. Now it's sort of every judge for himself. I want to have the law reflect my personal opinions. And if I can get one other vote on this panel, I'm going to win. And it won't matter what inconsistent precedents are already out there because the court won't go in bank to correct it. So that's one problem is you have chaos inside the court in a way that we never had in the 80s and 90s and a little beyond that. The other thing is appointments, of course, make a huge difference. And in a court that was dominated by people like Giles Rich and Howard Markey and many others, had some gravitas, had a center, had a core, had a spirit, a DNA almost. And in more recent appointments, you've lost that. There are now people on the court who, to my eye, are unduly hostile to patents. There are others who don't have clear views and can always be the second vote to a strong-willed judge who wants to get his or her own way. Now, if the actuarial tables are any guide here, there's likely to be several vacancies, maybe yet in the current presidential term. And if there are, it would seem to me that it would be in the interest of all factions of the broad, complicated, diverse stakeholder community to make sure that IP savvy, really good lawyers who believe in the patent system, not without restraints, not unbalanced, but who believe in a functioning patent system, get promoted to go on the court and get appointed by an administration. The Federal Circuit could be doing a much better job, but it's going to take some change of personnel.
Mm-hmm. Okay, guys, we're running up to the wire here, but there's one thing I'd like to, so maybe if you could give me your thoughts sort of in rapid fire that I think we mentioned and just came up as a question about the views of the NPRM on the Hill. And I guess maybe the quick question that we might be able to ask there is, are you anticipating that there will be hearings this spring or summer on what's going on in that NPRM or any ultimate rulemaking? And I raise that because I think we see that there's a number of members of Congress that are supportive, but probably maybe more members of Congress that are skeptical of what's going on there. So are you anticipating hearings, yes or no? I have a volunteer to go first. Brad?
I can go. I mean, I think you're going to have oversight hearings for PTO, and I'm sure this is going to come up. Those oversight hearings are par for the course. Maybe some of these changes are accelerating the timeline, but I don't think it's uniquely because of this. I think members of Congress are hearing more and more about constituent views on PTO operations. Again, you have fee setting authority renewal coming up. that I think is going to shape up to be a very interesting and heated debate.
Gene, I'd say there'll be a lot of pushback, not only in the form of hearings, but along many other vectors as well. And I think it's going to be a very rough year for the leadership of the PTO.
Okay. It's not music to their ears, I'm sure, but I think it probably is a good prediction. Phil?
Phil,
You're
no,
muted.
we're not getting sound out of you again.
Nope, not hearing. Joe, maybe you could go here for
Sure.
a minute.
So
What say you?
I'll make a bold prediction. Not only will there be hearings, there will be a House Judiciary Committee hearing on March 4th. I believe that's already been informally announced. And the last time they had a hearing when the PTO did a big rules package, the members were pissed off. I mean, you still have a number of members there who worked on the AIA who were part of that compromise. And to see the agency try to rewrite it on their own through regs without going through Congress, which is supposed to have authority to write the law, doesn't sit well with a lot of these people. And, this last year, in the first year of an administration, you usually kind of get a pass from your own party. No one wants to criticize people from their own side's administration. That tends to fade. I think you'll start to hear more people say like, well, why are we doing this? And how is it plausibly in the nation's interest to do these kinds of things at the agency?
Okay,
Phil, you
great.
want to
Phil,
give it
do we
another
have
shot?
it back?
Still,
Nope.
still not hearing you, Phil.
So give us a thumbs up or down. Do we get hearings, Phil? Thumbs up, thumbs down. Thumbs up on hearings. Okay. And is it just oversight hearings, or is it thumbs up on oversight hearings? Yeah. Okay. And will there be a special hearing about the NPRM called to just embarrass whoever shows up to answer questions? Who knows? Okay, so maybe. That's a definitive maybe. So on the way out, I'll ask each of you, give me your thumbs up or thumbs down. Are we going to have oversight hearings? I think yes, right? That where this will come up. Are we going to have specialized hearings where this is the only issue? Brad's down, a little uncertain. Who knows? Could be.
I think it'll be de facto the main issue in the hearing.
Okay. Yeah. All right.
Right. I don't think they're going to call a separate second hearing just for this.
Okay. All right. So this is irritating them, but not really, really irritating. So, okay. All right. Well, guys, thank you so much. I really appreciate you being here. And I think that was a fascinating conversation, if not more Debbie Downer than I thought it might be, but it is the reality that we face. So appreciate you all being